Well, good morning, good afternoon, and good evening, everyone. And why am I saying that? Because we're lucky today to have attendees from all over the world. So welcome again, everybody. I'm Christian Bolduc, a partner of the law firm Smart and Biggar, and it's a pleasure and a delight today to be presenting with Stéphanie Girard on the French Charter. So this is going to be hopefully an exciting presentation for all. A few housekeeping notes. The presentation will be about 35 minutes. There will be time for questions at the end. We encourage you to use the Q&A box instead of the chat. It will be easier for us. And so as we go along, please put in your questions in the Q&A, and we'll try to answer as many as possible towards the end. The webinar is being recorded, so the recording and the slides will be made available to the participants. I will now turn it over to Stephanie, but encourage Stephanie to start very slowly because the number of participants is increasing second by second, so that I assume others are going to be joining us shortly. But Stephanie, the floor is yours.
Well, thank you very much, Christian, for the introduction. It is also a delight to be presenting today with you. And hello, everyone. It's a pleasure to be here to discuss French language requirements in Quebec and how they interact with trademarks. So on the agenda today, first, we will explain what the French Charter is and how it impacts the language of commerce and business in the province. Then we will focus on a very specific exception to the general rules for commerce and business, which is the recognized trademark exception. And we will finish by discussing the consequences of breaching the French Charter and the changes proposed to the French Charter under Bill 96. And as Christian mentioned, we shall have approximately 20 minutes at the end of the presentation to answer your questions. So without further ado, the French Charter, what it is. The French Charter is a set of rules that were adopted by the Quebec government over 4 years ago. The goal of the French Charter is to protect the French language in the province of Quebec, and it gives French language the status of official language in the province. And this means that French must be used in government agencies, in school, in the workplace, and in commerce and business. When it comes to the application of the charter applies to businesses with an establishment in Quebec. And for your information, establishment includes a PO box. If your business is not established in Quebec, but offers products to consumers in Quebec through a retailer, it does not mean that the French language requirements do not apply to you. For example, you are not established here in Quebec, but your retailer offers products and services to consumers in Quebec. It's highly likely that your retailer will have to comply with the French Charter, and your products will have to comply as well. So the French language requirements will be relevant to your business, because we've seen in the past that retailers tend to transfer that obligation to the manufacturer of products. In today's webinar, we will focus on the language of commerce and business. So in the next few slides, we will explain the general rules for markings on products, for commercial publications, which include websites, and for commerce and business. So the first general rule, the markings on products. Markings on products must be in French, and this general rule applies not only to the markings per se, but also to the documentation being supplied with a product. For example, certificates of warranty, user manuals, registration cards, discount coupons, and the like. Other languages may also be used alongside French, provided that the markings in the other language are not given greater prominence than the markings in French.
Stephanie, I have a question on that, if you permit me.
Yeah.
I mean, greater prominence, does it mean just bigger, or is it something else?
No, in fact, it means that the markings in the other language must not be more important than the markings in French, whether in size, position, font, style. So in practical terms, if the markings in the other language are the same size as the markings in French or smaller, with the same color, same size, same position, same style, the no greater prominence requirement should be met.
Thank you.
You're welcome. The general rule for commercial publications is that they must be in French. As I mentioned in the beginning, commercial publications include websites. They also include brochures, flyers, catalogs, commercial directories. And as for markings on products, other languages may be used alongside French, and the no greater prominence requirement also applies to commercial publications. Something specific to commercial publications under the Charter is that they may be published as two separate versions. So one version exclusively in French and one version exclusively in the other language. Something important to bear in mind is that the French version must be as accessible and of no lesser quality than the version in the other language. So you must use the online translation tools with caution, because sometimes these tools suggest creative or surprising translations. For example, Made in Turkey was translated to French as fait en dinde, and dinde in French is the bird Canadians and Americans have for Thanksgiving dinner or Christmas dinner. So obviously, this is not a good translation, and I'm pretty sure you want to avoid that kind of translation, not only for your reputation, but also because it is not compliant with the French Charter.
So Stephanie, this advice you're giving regarding the quality of the French in the context of two versions, is it limited to that context?
No, it's not limited to commercial publications. For example, where there's French on a product or in commercial advertising or public signage, French must be of a good quality and it must be understandable. Otherwise, it will not be compliant with the French Charter. So
somebody is asking us, and I'm taking some questions along the way as I see them, but they're asking, so in that context that we're discussing here, equal prominence works. In other words, no greater prominence includes equal or lesser.
Yes.
Is that right?
Yeah, that's correct.
All right. So great. Thank you very much.
You're welcome.
So many, I see that many questions are coming in. So this is good. We'll try to address them as we go along sometimes, otherwise at the end.
Okay, good. Perfect.
All right. So here we are.
Okay, so a question we are often asked is whether all websites accessible in Quebec must be translated to French, and the answer is no. So only the websites of businesses with an establishment in Quebec that offer goods, services in Quebec must be translated to French. Of course, this is only a general rule, so it could be a good business practice to have a French version of a website if you target consumers in Quebec. The general rule for public signage and commercial advertising is that any storefront signage, any sign, poster, billboard must be in French. And again, other languages may be used alongside French, but here the requirement that applies is the markedly predominant requirement. So French must be markedly predominant, and this requirement is more restrictive than the no greater prominence requirement that applies to markings on products and commercial publication. In fact, there's a specific regulation that was enacted to explain what the markedly predominant requirement is, but essentially it means that the text in French must have a much greater visual impact than the text in the other language. That being said, some signs must exclusively be in French, and this is true for billboard sign posters of a specific size that are visible from a public highway. It is also true for posters, billboard signs on any means of public transportation, and this includes as well bus shelters. So now, instead of discussing each and every exception to the general rules we just discussed, we thought it best to focus on the exception that we feel is the most relevant to our audience today. So Christian, can you tell us more about the recognized trademark exception?
Thank you, Stephanie. I will definitely do that. And of course, we're going to talk about the recognized trademark exception in the context of those different scenarios or situation that Stephanie just discussed for us. One of the key point when we talk about the recognized exception is, first of all, of course, to understand what it means in practice. So a recognized, the law and the regulation, what it says is that a recognized trademark does not need to be translated in French, but there's a limitation there. So it's that to the extent that a French version of the trademark is not registered. So the key takeaway from this is that don't go register the French version of your trademark if you don't want to be forced to use the French trademark instead of the English one in the province of Quebec. Now, of course, if you don't register the French version, but you decide nevertheless to create and to use a French version of your trademark whenever it suits you, that's fine. But at least by not registering it, you don't have to use it. And that's the key takeaway on this one. Now, typically, a French version of a trademark is going to be what we would normally consider to be a direct translation. You know, sometimes a French version of an English or other language trademark may not be so obvious. And so maybe in those type of circumstances, it wouldn't be considered a French version of the trademark. If it's something that is not, I would say, in the nature of a direct translation, then maybe it's not so much a French version of the trademark in another language. A recognized trademark has been clearly accepted to be a mark that is either registered or a mark at common law. Now, for those of you listening to this presentation today that live in countries that are not, common law jurisdictions, like Canada, the US, the UK, India, New Zealand, Australia, and so on and so forth, and where it's a concept of civil law that rules. Common law marks are basically use-based marks that have not been registered. Now, what's important here to understand, and we're gonna basically dive a little bit further into the two concepts, is that the first one, the registered trademark, it means that in this country, Canada, it means that the federal agency responsible for registering trademark that we call the Canadian Intellectual Property Office, in short, CIPO, has issued a certificate of registration for the trademark that you don't want to translate. Now, the benefit of having a certificate of registration is that it makes things so much simpler. In other words, when we look at how things work in terms of managing the French Charter, the way it typically works is that somebody in the public is going to file a complaint. The body responsible for enforcing the French Charter that we lovingly refer to as the Oqrf, which is the Office Québécois de la Langue Française, will investigate the complaint. And if it determines that there is an issue or a violation of the charter of the regulation, it will send a formal letter to the offender. The offender could be the manufacturer, could be the distributor, could be the retailer, whichever applies. Now, this letter will request a response within a certain period of time. If a satisfactory response is provided within that period of time, then typically the matter is resolved. Now, if the issue that has been raised is the fact that a trademark appears on a product packaging and the trademark is in English, and in terms of response, we provide a copy of the certificate of registration showing that the mark that appears on the product is actually registered, the matter is resolved. This is done, and there's nothing else that needs to be done. Now, that is as easy as it gets. Now, if the matter is not resolved in front of the Oqrf, then the Oqrf will pass this complaint to basically the person responsible for enforcing the penal section of the law and regulation that we call the DCPP. And if that person determines that the case warrants being prosecuted, then a lawsuit will be launched and the defendant will be sued in the Cour du Québec with the consequences that Stephanie will discuss a little bit later. So that's under the scenario where we have a registration. Now, if we go back, and instead, we decide to rely on an unregistered trademark, which we call a common law mark, which is a mark that's been used, promoted, advertised, to the point where it has acquired a certain level of goodwill and recognition in the market. Well, that works as well, but that can be quite limited and burdensome. Now, limited, we'll talk about it a little bit later when we go on in the presentation. But burdensome means that you do not present common law evidence of use in front of the Oqrf. The Oqrf is not equipped to address that. They don't have the expertise. If, as a defendant, as somebody, you've received a letter from the Oqrf saying that you're in breach of the charter and the regulation, and you decide to rely on your common law rights, that means that you're going to have to prove your common law rights in court and defend yourself. And so we'll address that a little bit later, but that obviously means that it's going to be taking a lot more time, and there will be a lot of uncertainty as to the potential outcome of that approach that you decide to take. Now, furthermore, on the common law aspect of the recognized trademark exception, just to give you an example of one of the recent cases that we've seen issued by the court, a decision from a few years ago. It's just to give you an idea of the scope of common law rights. The decisions that we've seen issued, such as this one, were decisions where the people who had received the complaint and had been prosecuted had use going over many, many decades, and the use was very extensive. And in those contexts, the common law mark was recognized as such by the court, and the exception was deemed applicable. Now, of course, we don't have enough decisions to tell you what's the baseline, how much use and promotion and advertisement of a trademark is sufficient for the Cour du Québec to recognize it as a common law mark. Unfortunately, we don't know. And that's why, maybe it may be a risky endeavor unless you have very substantial use.
Christian, it's my turn to have a question for you.
Yes.
So if I filed a trademark application in Canada and my trademark has yet to be registered, can I rely on this pending trademark application to claim the recognized trademark exception?
Unfortunately, no, you really need to have a certificate of registration.
Okay, thank you.
All right, pleasure. Now, how to leverage this exception in practice? Well, here, what we recommend is register your slogans and your expressions. And then if ever you get a complaint filed and a letter from the Oqrf, you can provide the certificate of registration, and that will take care of the matter very swiftly. Of course, in the case of slogans and expressions, you can also rely on the common law exception, is, as we explained a bit earlier, a little bit more or way further more burdensome and risky. The same applies to logos, images, drawings combined with words. That works as well. Of course, as in the case of slogans, if it's registered, much simpler. If it's common law that you want to rely upon, also possible, could work to the extent, of course, that you can convince a court or a judge that what constitutes the logo works as a trademark and is recognized as such. This becomes way more challenging, as you will understand, if what you want not to translate is an entire label of a product. And typically here we give you a very simple example. We didn't give you a real life one. And of course, this we're basically divulging the fact that I do like whiskey very much. So here you go. But that being said, I'm not encouraging people to drink. Okay, so not at all. Going back to what we're talking about here. So a label in its entirety can be registered to the extent, of course, that there's registrable subject matter in it. And then you can provide the certificate to the registrar, to the Oqrf, and that's going to solve the matter. Now, think about it from the point of view of a common law mark, where you have an entire label of a product with a lot more writing material on it than this label that appears in the slide. And you're trying to convince a court that family-owned distillery is actually a trademark or part of a trademark, and that since 1888 is also part of a trademark, this obviously could prove a lot more challenging than just showing your certificate of registration to the Oqrf and not having to go to court to try to prove that some of the language that appears on your label functions as a trademark, when in reality, it most likely does not. Now, in Canada, you may have heard we face very, very serious challenges with our trademarks office taking, close to 3 years to actually examine the trademark, not the timeline to registration. It's actually timeline to examination. So it can take more than 3 years to get a registration. And that, of course, presents a serious challenge in terms of planning and managing risks. And so it may force some businesses to commercialize in Canada, but to avoid the province of Quebec until such time as the mark is registered, which from a business perspective is not ideal, but that's unfortunately part of the various scenarios that need to be contemplated. I'm mindful of time here, Stephanie, so I'm going to move a bit more quickly on some of those slides. So the other thing that needs to be considered are the criteria for registration. Not everything is considered registrable in Canada, and definitely not since the amendments to the Trademarks Act that came into force in June of 2019. If we look at the example of the label again, as long as there is something within the label that's registrable, then the whole thing should be registrable. So it's the concept of adding something distinctive to the thing that you're trying to get registered as a trademark. The other challenge that you may have is that, for example, a slogan, a label, a logo can evolve over the course of time. So you may have a registration from 5 or 10 years ago, but the mark that appears on the products today in 2021 is not the same anymore. So it will be a matter of how much different the mark in use is from the mark as registered. That's going to be key to determining whether or not you're going to be able to rely on your registration to avoid having to translate the mark that appears on your product or that is associated to your services. And that takes us to another aspect of the recognized trademark exception, the trademarks outside a building. And I'm turning it again to you, Stephanie, please.
Thank you, Christian. As Christian mentioned, a recognized trademark does not need to be translated to French, provided that no French version of the mark has been registered in Canada. And this is true for a recognized trademark outside a building. However, in this specific case, there's an additional requirement called the sufficient presence of French requirement. As per that requirement, there must be some French nearby the recognized trademark. So to comply with that requirement, you can add descriptive language nearby the recognized trademark. So in the example, librairie, which means bookstore, you can add a slogan. In the example, les meilleurs livres en ville, the best books in the city. Or you can add an indication as to the nature of the business. I will translate what is written in French in the last example. We are proud to offer new and used books at competitive prices. And now let's discuss the consequences of breaching the French Charter. There are two types of consequences: the financial consequences, in other words, the fines, and the reputational consequences. In our view, the fines do not really have a deterrent effect because they are not substantial at all. For example, for a business, for a first offense, the fines range between $1,500 and $20,000. We've noticed in the past that fines tend to fall on the lower end of the spectrum, so approximately between $1,500 and $3,000. When it comes to the reputational consequences, when a business receives a negative decision, this decision is public, so it may be reported in the media. And here in Quebec, French language is a sensitive topic. So if that decision is reported in the media, it may be bad publicity for your business, and I'm pretty sure you want to avoid that kind of publicity.
Stephanie, I have a question for you.
Yeah.
So in practice, what's the range of the fines that we see for businesses issued by the court?
For businesses, for a first offense, $1,500 and $3,000. This is what we see usually.
And if an infraction is ongoing, is the fine multiplied in time, or does it remain the same?
It remains the same. So it's a fine per category of violation. So even if the violation is ongoing, the fine will be the same. So usually between $1,500 and $3,000.
That doesn't seem like much, right?
It's not much. No, it's not much.
Thank you.
You're welcome.
All right.
Speaking of a sensitive topic, Bill 96, in other words, the changes proposed to the French Charter. So Bill 96 is a bill that was introduced by the government of Quebec in May 2021. The goal of Bill 96 is to strengthen certain provisions of the French Charter. We do not know when Bill 96 will come into force, and we do not know if the text of Bill 96 will be amended before it comes into force. What we know, however, is that there will be a grace period to comply with certain provisions. And it is our feeling that Bill 96 will come into force sometime in 2022. Bill 96 does not impact the recognized trademark exception, except for public signage and commercial advertising. For public signage and commercial advertising, the recognized trademark would be restricted to a mark that is registered in Canada. So in practical terms, the owner of a common law right would no longer be able to rely on its common law rights in its common law mark to claim the recognized trademark exception. So the mark will have to be translated to French. In addition, for recognized trademarks that are displayed outside buildings, the sufficient presence of French will no longer be accepted. It will be replaced by a requirement that is more restrictive, which is the markedly predominant requirement. In our view, this would mean that text in French or inscriptions in French will have to have a much greater visual impact than the recognized trademark. So adding a slogan, adding a descriptive language or an indication as to the nature of the business could no longer be sufficient, but we will keep monitoring this proposed change. And when Bill 96 comes into force, we will publish an article on that topic. So stay tuned for the article.
Thank you, Stephanie. And for people to know, right now, it seems that all the political parties in this province are aligned that there is a necessity for this to happen. So as Stephanie said, this bill will likely come into force, and we'll keep you up to date on that.
So other changes proposed by Bill 96. Bill 96 would extend the powers granted to the OQLF. For example, the OQLF will have the power to ask the court to issue an injunction to remove products that are not compliant with the French Charter. And the fines would also increase. So for a business, for a first offense, the fines would range between $3,000 and $30,000 instead of $1,500 and $20,000. But in our view, the most important change concerning fines is that if a violation continues for more than 1 day, each subsequent day is considered a distinct violation. So the fines could easily double, triple.
Thank you.
You're welcome. Okay, so now it is time to answer your questions. Also on this slide, there's a list of useful resources. So the text to the French Charter, to some regulation that I referred to in the presentation, Bill 96, and the OQLF website. And just to remind you, we will share the slides with you after the presentation. So you will have access to these links. And I believe someone from our team will copy those links in the chat.
It's already done, actually.
It's already done? Good, perfect. So the first question. Okay, so how many complaints are filed with the OQLF and how many of these complaints are referred to the Court of Quebec? This information is available on the OQLF website. If I recall correctly, for 2019 and 2020, less than 4,000 complaints were filed with the OQLF, and approximately 1% of these complaints were referred to the Court of Quebec. So the vast majority of these complaints were either unfounded or they were simply resolved with the OQLF. And now the other question. Does the OQLF publish guidelines on French language requirements? And if so, where can I find them? Yes, the OQLF publishes the guidelines on French language requirements. These guidelines are available on the OQLF website. The only small detail is that they usually are only available in French. Another question. If my trademark is registered in another country, but not in Canada, will I be able to rely on the recognized trademark exception? That's a good question. In fact, you cannot rely on a foreign trademark registration to claim the recognized trademark exception. But what you can do if your trademark is used in Canada and has acquired some level of recognition in the market, you can rely on your common law rights in that trademark to claim the recognized trademark exception. But you will have to do that in court. As Christian mentioned, the OQLF is not equipped to manage evidence of common law rights. So Christian, do we have, I believe we have other questions.
Yes, we have many questions, actually, very good ones. So let me take a look at those and see. So somebody is asking if I sell product online and the website is accessible to Quebec residents, and Quebec residents can make purchase from the website. Does the charter apply to these online sellers? I believe, Stephanie, you may be best suited to
answer that question. I will answer the question. In fact, if you're not established in Quebec, if your products are only available online, they are not available at retail in a brick and mortar store in Quebec, then your website could be only available in English, but maybe this is not a good business practice. I will let you decide. but the answer is your website can be exclusively in English in that specific scenario.
So that's to the extent that you don't have a place of business in the province of Quebec.
Exactly.
Okay. And does the same rationale apply to social media accounts?
Social media are considered commercial publications. So yes, the same rule as those for commercial publication applies to social media. But if someone writes, for example, on your social media account only in English, you can answer only in English if the person wrote to you in English first.
Somebody's asking for the question of, no greater prominence that they refer to as equal prominence. So remember, no greater prominence means equal or lesser prominence. And the question is, does the French need to appear above or below? Does that matter?
No, it doesn't matter as long as you comply with what I said in the presentation. So you have to pay attention about size, color, style, font. So no, it doesn't matter if the English appears first.
Is having a warehouse in Quebec enough to make a business subjected to the French charter?
I would say yes. I don't know what you think about that, but to me,
I think the same thing, actually.
Yeah, good,
Yes.
Perfect.
Yeah, and then if products are imported in the province of Quebec, and I read into that they're imported, which means they're available at retail in a brick and mortar store, then the answer is they're going to have to be compliant to the French charter. And, if the label and the material that come with the products are not compliant, then you could potentially face a complaint. Now, we didn't get into the details of this earlier, but do bear in mind that if nobody complains about the product, then you're not going to have an issue. Now, don't take into this that I'm encouraging you to violate the charter and the regulation. What I'm saying is that it's a risk, it's a business risk, and it's up to businesses to decide whether or not they want to take that risk or not. Of course, the risk is much greater when we're thinking about consumer-facing goods versus products or services that are more in a context of business to business. It's all a question of exposure, because although the Oqrf has the power to, investigate on its own a situation, in practice, they don't, and they wait for people to file a complaint. So just for you to know. Another question that we have here, and keep them coming, there's many. Let me just see here. Is it acceptable if the .ca version of a website is in French and the .com is in English? Well, that's an interesting question.
Yeah, that's interesting.
What do you think about that? Should we not consider both as two separate things, and both need to be available in the two languages?
Yeah, so I think that .ca would have to be available in French and in English, and same for the .com. To
the extent, of course, that the business has an establishment in the province of Quebec.
Yeah.
Okay, thank you. Does a trademark need to be registered to be a recognized trademark? I believe you've addressed that, and I don't have necessarily the timing here of those questions. So with respect to when we've addressed some of them, so apologies for that. So I think we've already answered that a pending application doesn't cut it. It needs a registered trademark unless you want to rely on the common law rights. And I believe oh yeah, somebody is asking a tricky question. They're saying, What if I have a pending application, I get a complaint, and while the complaint is being essentially processed, I get a certificate of registration. Will it still be considered a violation? You know, I don't know about you, Stephanie, but I've never faced that situation in practice, but I would suspect that you don't have to do anything because you have a certificate of registration that's been issued, and that should resolve the matter. And I don't think the OQLF would pass on the file to be prosecuted in court now that you have a certificate of registration. I think that in practice, that's what would happen. Does that make sense to you, Stephanie?
Yes, it makes sense.
You know, I'd be surprised otherwise. Now, somebody's asking, what if I have a registered trademark for a main mark, and then I have a submark that appears under the registered mark, but the submark is not registered. Then I think that your certificate of registration doesn't save the day, obviously, for the submark that is not registered. But if it's a submark that you've used considerably in the market, then the common law exception would apply in that case. You know, and that to the extent that there are risks in doing so, as we've addressed already, so that should be available to you. Are the fines on top of the cost of litigation? Absolutely. You have to defend yourself, which means you're going to have to hire attorneys and have to address that. So in practice, the fines are insignificant currently compared to what you're going to have to pay to defend yourself in court. Now, does a registration of a trademark automatically makes it recognized? That's one of those questions that we can answer fairly quickly, right, Stephanie?
Yes.
It does. So
It does.
That's it. It's done. If your packaging is not compliant, how long do you get to change it? Is there any risk of having it removed from shelves? So that's a very interesting question. So in practice, when you get a complaint filed with the OQLF and the OQLF finds that the complaint is valid and there is a violation of the charter or the regulation, they write a letter to the business that is found to be in breach. There's typically an ongoing dialogue there. And if the business says, for example, I recognize, I didn't realize, I recognize there's a problem. Can you give me a few months to phase out my products, replace the packaging? In practice, typically, if the request is reasonable, the OQLF is going to be reasonable, it will accept it. And so in practice, if you propose a timeline that makes sense to the OQLF in terms of length, then the OQLF will accept the proposal. I mean, as Stephanie said, there are not that many cases that are referred for prosecution, and that basically testifies of the fact that the OQLF is typically a body that is reasonable to deal with, unless you don't propose anything that makes sense. Now, there's somebody asking about the OQLF, ramping up enforcement and how it's that playing out in the market. And they're asking if is the signage on the building still the target of the Oqrf. I don't know if you're comfortable answering that, Stephanie, but
Yeah, the Oqrf currently focuses more on public signage and the language of website than on manufacturers of products or markings on products. So what we've noticed recently is that the fines are awarded for non-compliant websites and non-compliant public signage.
thank you. So somebody's asking about the range of the fines being pretty broad, and if we are aware of the factors that are going to be taken into consideration by the courts to issue the fine. At the end of the day, we don't know much. And as Stephanie said, the actual fines are pretty much all the time at the lower end of the range. Even if the defendant has had or has displayed behavior that is not necessarily exemplary. And so I would say that my take on it, and of course, Stephanie, feel free to add to that, is that under the current regime, it will remain that way. But if Bill 96 comes into force, the feeling I believe I have, at least, is that this is not going to work anymore, and that people are going to have to, be mindful that if they behave in a fashion that is considered not acceptable, then the fines are going to move towards the upper range. I don't know if you share my views on that.
I share the same view.
All right. So somebody's asking about the public perception or PR risk of registering an entire label. I would say that there's always a risk, but in our experience, that has never proven thus far to be a problem. In other words, what will the media pick up and publish in their newspapers are typically cases that are the subject of a decision by the court. The public is not aware, the media are not aware of the complaints that are filed with the Oqrf. They have no idea. And so, the PR risk of registering an entire label, I don't think is a material risk at all. I don't know if you have a similar view, Stephanie, on that.
Yes, similar view.
All right. Now, you mentioned that the court has the power to remove signage if the company does not comply. Does the court have the power to remove goods from shelves? The answer is no. They don't have that power. So that's comforting in a way.
Under Bill 96, they should have that power, but not under the charter for the moment, at least.
Yep. Somebody is asking if, wait a second here. Is it sufficient to have two separate social media accounts, one in English and one in French, very much like the two versions of the website? Would that work?
Yes, it would work.
All right, well, thank you. Now I pause between each question because somebody is nice enough to remove the questions that were answered as we go along. Now, somebody is asking about running a contest online that is available to those in Quebec. Have the question and answer, do they need to be provided in both French and English, or would it be a problem if they're only in English? I assume that would be a problem if you're running the contest in the province of Quebec, very much like any commercial publication. I would suspect that this would have to be compliant as well. Somebody's asking about domain names. Do domain names have to be in French or both in French and English? Domain names are not commercial publications in and of themselves. Domain names do not need to be translated. That is not a requirement, unless, of course, your domain name is your trademark. It's the trademark under which you do business. It's the trademark that appears on your products. Then, of course, whatever Stephanie has said earlier will apply to that, of course, that's for sure. Now, somebody's asking scenario where the business doesn't have a brick and mortar store, but it does have employees in the province of Quebec. So if you have employees in the province of Quebec that are basically running the business or a portion of the business, I would suspect, and you tell me if you disagree, Stephanie, that the charter will likely apply to that business.
Yeah, we're on the same page. I agree with you.
All right. Now, another question on equal prominence or no less, what was it? No greater prominence. So yeah. It's the question about size. When we discussed earlier, is it just size? So for example, if my French is bigger than the English language that appears, for example, on a product packaging, am I good to go? Or there are other factors that should also be considered?
Yeah, it depends, because the text in English, even if it is smaller, could be in a more noticeable color. For example, French could be black and English could be red. So this would probably not comply with the no greater prominence, but of course, in my view, it's a case-by-case analysis. So usually we like to review the material in order to provide our opinion.
Thank you very much. And I guess that applies also to in the context of businesses. And imagine the French on a sign not being lit, but the English smaller being lit. Perhaps at night, the English would have greater prominence.
Yeah, you're right.
It's something to bear in mind. If we have an English site that is mirrored in French, is it okay to remove some content that may not be available or applicable or relevant to the French consumer? That is a very interesting question.
I would say, why not? If the text does not apply to consumers in Quebec, I don't see it as being problematic. I don't know what you think, Christian.
Well, I think it's as you said earlier, it's like what lawyers always say, it's a case-by-case basis. Yeah. But for example, if you're publishing something for people outside of Canada, for example, then it's not at all relevant or directed to people in Canada, including Quebec, then in that case, I would say, yeah, they probably don't have to translate those texts that appear on the website. So we're near the end of our presentation. It's 12:58. I don't think we have any remaining questions, and we've made a good time. So thank you very much, Stephanie. I want to also thank everybody who attended the webinar. It's been a pleasure. And of course, should you have any questions for us, or require opinion, we'll be delighted to oblige. Otherwise, have a great rest of the day, and stay tuned for other publications and webinar in the coming months.